The Philippine senator and ally of former President Rodrigo Duterte remains holed up inside the Senate building, locked in a legal and political standoff for close to 40 hours.
Ronald de la Rosa is under protective custody by the Senate's new president as he seeks to evade an international criminal court arrest warrant. He's appealed to President Ferdinand Marcos Jr. not to enforce the warrant to send him to The Hague. De la Rosa, the former national police chief, was the key enforcer in Duterte's anti-drug campaign and is wanted by the ICC for crimes against humanity.
Federal agents were waiting for him at the Philippine Senate to serve the order, but the lawmaker ran and the agents gave chase. Dramatic scene of him dashing through halls and stumbling on the stairs was captured on CCTV. In minutes, De La Rosa reached the Senate chamber where the arresting officers have no authority.
Riot police have surrounded the Senate complex as the standoff continues. De La Rosa's lawyers are petitioning the Supreme Court to temporarily block his arrest. The ICC arrest warrant was issued confidentially in November. 5 senators are now urging him to surrender. The lawmakers and the Marcos administration underscored the limitations of the Senate's ability to provide protective custody. And for a closer look at this story, let's speak to Jennifer Trahan. She's clinical professor at NYU's Center for Global Affairs and director of the Concentration in International Law and Human Rights at NYU. Professor, thank you so much for joining us. I want to start by asking you about the circumstances involving, the senator. They appear to be very similar to Rodrigo Duterte's extradition to the ICC at The Hague. Are they exactly the same, or are there some specific legal differences?
Well, the basis for the court proceeding is the same. The Philippines became a state party in 2011. They withdrew in 2018, effective in 2019. So the basis of jurisdiction is that the court has authority for crimes during that time period between 2011 and 2019. So the basic allegations stem, of course, from the war on drugs and the allegation of crimes against humanity, that extrajudicial killing would be murder, potentially as a crime against humanity, and what converts ordinary murder into a crime against humanity is if it's widespread and systematic and committed pursuant to a state policy.
So, Professor, this case certainly highlights the gap between ICC jurisdiction and actual enforcement on the ground. How should we understand that gap?
Exactly. So the court has a number of outstanding arrest warrants. Of course, it's also had a large number of warrants executed, but the court has no police capacity, so it relies on states to surrender individuals and get them to the ICC. So it really is up to the dynamic in the state whether this is going to happen. States that are parties to the International Criminal Court Statute owe cooperation obligations. Of course, Philippines is in a different situation because they only formerly were a party to the International Criminal Court Statute.
So which leads me to the question, is President Marcos in any way obliged or going to consider enforcing the ICC warrant, given that it hasn't rejoined the ICC?
I really cannot predict politics in the Philippines, so I'm not going to conjecture on that one. It really is up to a country. As I say, if they're an active state party, they owe a legal obligation to effectuate arrest warrants. It's a little different that the Philippines is a former state party.
Okay. The reason why the ICC first stepped in is because they found domestic investigations were not sufficient enough. So in theory, could a renewed national investigation reduce or even remove the need for ICC involvement?
Exactly. That is called the complementarity regime before the International Criminal Court. If a national country is willing and able, so willing, it has to be a genuine investigation and prosecution. It can't be a sham investigation or prosecution. And that is up to the ICC to judge the bona fides. So the national authorities do have first bite at the apple. So any country could, in a way, divest a case from the ICC by doing the case itself.
Professor, I just want to quickly go back to what you were saying about warrants and actual transfers and arrests. The ICC here has a mixed record. So, when we look at this case and compare it to actual or outstanding warrants against leaders like Benjamin Netanyahu and Vladimir Putin, I mean, does it provide any context? Does it provide any signals in terms of, whether or not this will in any way materially change those outstanding warrants as well?
Well, I will say, I think it's difficult for the ICC to get particularly high-level individuals to the court while they're still in power. It's a little easier when they're no longer in power, but that doesn't guarantee the transfer. Ex-President Bashir of Sudan has been wanted for many years by the ICC, including on charges of genocide. So states would have to really work on making these transfers happen. So I will say it is easier to proceed against ex-officials. Obviously, there is something also known as a sealed warrant, because we know the warrant against Senator De La Rosa was originally sealed. And if individuals don't know there is a warrant out standing against them, they're more likely to travel and be apprehended. So there is also a careful balance the ICC has to strike. If it does only sealed warrants, it won't look like it's doing any work. But if it makes all its warrants public, I think it's less likely to get the transfers. Now, that's just the general rule. So there are both sealed and unsealed warrants.
I hear you on that particular aspect, but I want to ask you a question that's often asked, and I'm not suggesting that this whole process is not effective, but that perception, that any leader or individual under an ICC arrest warrant is only going to face trial when they've lost power to their political enemies, which means sometimes that's never going to happen. So help us understand, why is this process still useful? Why is it still important?
Yeah, first I would say never say never. I have been working in this field so long. I remember we didn't envision getting President Milosevic to The Hague for trial, or Radovan Karadzic, or Charles Taylor to the special court. So sometimes you don't know how the political cards are going to unfold. So for that reason, I think it's very important that courts proceed where the evidence leads them. And an outstanding arrest warrant also is not of no value. It tells the world that the court is investigating and pursuing the situation. For the interim measure, it may operate as a travel ban against a leader. They may not want to undertake travel when they know it would cause them to be arrested. Right now, Senator De La Rosa is obviously, worried about even leaving the Senate chamber. So an outstanding warrant, I think, expresses that the court is proceeding and pursuing the charges. It is sometimes a long wait to get to justice, but there are no statutes of limitations for genocide, war crimes, crimes against humanity before international tribunals. So the crimes do not expire.
You did touch on the political side of this case. This episode indeed is happening in the wider political struggle in the Philippines between the Marcos and Duterte's camp, including the impeachment proceedings involving Vice President Sara Duterte. I wonder just how interconnected are these legal proceedings and domestic political battles?
Well, I would always wish that a country would surrender someone because it's the right thing to do, and they're pursuing the rule of law. I'm not oblivious to the fact that domestic political dynamics can play into a country's decision-making. So maybe the ICC gets the individual, but it isn't out of a profound commitment for the rule of law. In a perfect world, it would be.
Okay, Professor Trahan, we'll leave it there for now. Thank you very much for your time today. Jennifer Trahan, Director of International Law and Human Rights Concentration at the NYU.